And we want to thank all those, both online and offline, that took time to submit their questions. And gentlemen, I want to actually get started with a question that was submitted offline. Mr. Salvon Mitchell, the CEO of Allied Security Limited, has asked, if I have a client who has specified that under no circumstance I can put on his location a security guard who did not take the vaccine, what is my position? Can I leave this to open dialogue between you gentlemen?
That question. The thing is, the answer to that would lie in the existing contractual arrangement with that third party. So it is not what does the contract that Allied would have had with this third party say, and did it allow for that condition to be applied? If not, the question of asking the Allied Security, I should say, to put only guards on my location that is vaccinated, it will be an attempt to frustrate the contract because the contract didn't speak to that. However, there are situations, and I would say, and this is one of the things that I really look forward to the Ministry of Labour policy on this, because sometimes these policies come out and it is not well thought out. Third party situations like these, and we have a lot of clients who are not just security companies, but companies that are third party, have workers working for other companies and that kind of thing. And these companies may attempt to interject conditions that would affect the employment relationship of the first party and the employer and the employee. And these things, as Rollo would have said in his contribution, need dialogue. We need to have dialogue on this. You can't just terminate a worker because he didn't take, or he refuses to take the vaccine for whatever reason. Some kind of dialogue must be had, and at some point in time, you must have a meeting of the minds, some kind of consensus on what we're going to do and how we're going to, if at all it ends up where we have to part ways, then the question of compensation for my time, the question of all that must happen. And if it didn't happen, then we will have some kind of, we may have disputes or grounds for dispute. Rollo,
Okay.
Yes,
Alana?
and you're quite right, Stephen. And there must be some discussion, and right away, this discussion about third party
Yeah,
and
Alana,
third party contract
yeah.
carries with it certain logical questions, because you would ask yourself, the unvaccinated worker is a danger to whom? And if you say the unvaccinated worker is a danger to everyone, then is it a requirement to enter onto the compound that you must be vaccinated? Otherwise, the argument is kind of a contradictory. It's kind of flippant in that way, because one would think that if everybody else is vaccinated, the unvaccinated worker is actually a danger to himself or herself, as that may be. But if entering the compound or the general public, they are not asked to be vaccinated, or they're not denied entry based on their vaccination status, how then do you argue? How fruitful is the argument that the unvaccinated worker, just as the unvaccinated visitor, poses a danger or threat? So again, these are discussions which the employer, the third party, must have. We do respect employers' rights, again, to ensure that there's safety in the workplace, and they have their prerogative for policy making. But we are saying that when you have dialogue, you'd begin to flesh out some of these things. You will begin to talk about how fair it is, how reasonable it is, how possible it is. Are the vaccines again available? Are they readily available for my workers? And there may be a case where the third party contractor does not have a ready supply of unvaccinated workers at the time of the location. Maybe they could switch shifts. Maybe there might be other alternatives to that situation. Again, hard and fast rules will not bring fruit, and there must be a discussion between the parties.
Thank you.
And Rollo, yeah, and you would have spoken in your presentation about the unilateral alteration of terms and conditions. What we need to understand is that my existing contract on both sides didn't say anything like that. Didn't say that I have to have a vaccine. So if you want to now, you now want to interject new conditions in my contract, we have to have a discussion. Otherwise, it will be a unilateral alteration, and then you will have to face there are legal remedies for that. So the question is always the contract, in my opinion, and unless the government goes to Parliament and make new laws, and because this is a contentious issue, because this obviously is a constitutional issue, I am not seeing the possibilities of that, because that would require some kind of special majority, and therefore this will remain contentious. So I would recommend in cases like these that we simply have the dialogue with the workers. We get the right professionals to meet with you and treat with these kind of issues, because every single situation may be different. This is a third party situation, but this is a situation. This may not be the same situation as the normal employer employee, but it is a situation that would require some kind of thinking and some kind of solution in terms of from that could only be had from a dialogue. Right, Elena?
Sure, thank you, gentlemen. We want to move next to a live submission. And Samoya asks,
Elena?
will the... Yes, Stephen, are you able to hear me? Ronaldo, are you hearing me?
Yes, I am.
Okay, great. Samoya asks, will the employer be held liable for adverse effects if the vaccine where it is forced upon the employee? And I want to read that for you again. The question asks, will the employer be held liable for adverse effects of the vaccine in cases where it's forced upon the employee? Gentlemen?
Well, I would say, remember, and I don't want to get into
Good. So,
but I would say that, remember, the end of the day, this is a choice issue. You would have chosen. Force speaks to the policy of the institution or etc. But to say that the employer forced you to take the vaccine, I do not think that argument will totally be able to be substantiated. At the end of the day, there are choices and there are consequences to the choices. So you would have a choice, and that was evident in the said Czech Republic case that I spoke about, where the judge said because of the parents' unwillingness to take the vaccine, and the government passed a law that the children will not be able to attend school without the vaccination. And even though the court ruled in favor of the state, saying that for public health purposes, the court felt that, it was a preventative measure, not a punitive measure, that they were able to institute such a law, and they were able to uphold such a law. The party then petitioned the courts about the child and the child's inability to be educated. And the judge was emphatic in saying that was a consequence of the choice that your parents made. So your parents made a choice not to vaccinate you. Therefore, you were not allowed in school. And as egregious as it seems, it was an outcome and a consequence of your action. So I don't know how those challenges will be to argue that you were forced, like physically forced and otherwise. And we preach consequences. There'll be consequences. If you do take it, you consider it. If you don't take it, you consider it as well.
Mr. Mathison,
Yeah.
any views to
And
share?
I did hear the Prime Minister say in answering that question sometime that you take this vaccine at your own risk. While that may sound unfortunate to some people, it speaks to the fact that you have a right as a human being and you could choose to take it or not to take it. And nobody could tell you unless there's some law made by Parliament that says that you have to take it. I know of situation, and I think the British government, for instance, have chosen to indemnify vaccine companies to the tune of, I think it's £120,000 to some extent. And in those cases, yes, you can sue, but I am not too sure if you can go to the court on a matter like this where it was your choice to take it. No one is saying that you have to take it. And in any case, there seems to be a lot of confusion as in relation to the vaccine and what it could do. How could you tell me that I am taking a vaccine by the definition of a vaccine, and I still have to wear a mask to protect myself from persons who didn't take the vaccine? That really doesn't make sense, any logical sense to me. So clearly, this may not really be a vaccine. This may be just some kind of temporary submeasure, something. It really didn't meet that. But I am not trying to put any spokes in the wheel. I know the CDC has said that in question of the booster, because Pfizer is saying that according to its experience in Israel, that the efficacy is went down to something like 64%, and they are making a case for a booster. In the first cases, Dr. Fauci would have said that there's no question of that. There's no need for a booster. But then he turned around sometime yesterday and said that we shouldn't the question of a booster and the question of the efficacy of the vaccine is two different things. So clearly that frightens people. People are now asking questions as to whether or not I should take this, whether this is a test, whether this is an experiment, that kind of thing. The fact is, we are here to talk about how all of this is going to affect the employment relationship, and how can an employer, or should an employer, say to an employee, I should take the vaccine in order to come back to work? And that is the question. We are saying that if that has to happen, it should have some kind of dialogue, and that dialogue should be had with both the employer and the employee, and a decision has to be made, even if it means if it means that an employee has to be terminated, or not terminated, I should say separated, then there must be some kind of remedy to be able to do that, because this will be put to a lot of tests. As Rollo was saying, the industrial court is a court of common sense, and it looks at the fairness, the reasonableness, the equity in the decision made by the employee. And Section 10 of the Industrial Relations Act says, notwithstanding any other law, notwithstanding any other legislation, we look at what is fair, what is harsh, oppressive, and contrary to good industrial relations practice. So at the end of the day, that is the backdrop to how in treating with workers and treating with as employees, and even within the situation with employee, the dialogue that is necessary to deal with this. Elena.
Thank you. I want to bring an offline submission. We have a question here from Joanna Sylvester that says, if my housekeeper refuses to take the vaccine, but we have underlying illnesses, could we fire our housekeeper? And I want to read that again. The question from Joanna says, if my housekeeper refuses to take the vaccine, but we have underlying illnesses, could we fire our housekeeper? Gentlemen?
Well, I don't like the word fire.
Yeah.
I don't like the word fire to begin with. We do recognize that in some situations, especially in domestic situations with domestic workers, where the health of the client is juxtaposed to the health of the service provider, they may be there might be different considerations in that employment relationships, because again there might be no alternatives for the employee. We had a client not too long ago, and Stephen will surely expound, that was facing a domestic situation. However, the employer had no other alternatives because the person whom the worker cared for had comorbidities. They were not able to be vaccinated, and they were in serious fear and trepidation. So we understand, and Stephen will go into some of the details sometimes, that logically some employment relationships will be inevitably end because of this pandemic, and that is the truth. We will not like to face it, but because the nature of work has changed and there are public health issues at the forefront now, we envisage that by mutual conversation, by mutual dialogue, some employment relationships will have to come to an end. How it ends, what is the process, what are the methods used, what are the compensation issues, is another dialogue that you would need expert advice to guide you, because it's not just a bye-bye situation. Remember, I did say that there are consequences for both employee and employer. Anyhow you take it, in every scenario in this pandemic, it's not just goodbye, we thank you. So therefore, we do envisage in a domestic situation where there may be no other alternative but to end the employment relationship. That is my firm view, and I understand that. How that is done is the real question. Stephen.
Right. So this question really exemplifies why we need to have these kind of dialogue, because a domestic worker really does not fall in the same way as a worker and is not treated the same way under the Industrial Relations Act. However, this is a good example of the difficulties that employers and employees may have to traverse at some point in time. We had, as Rollo was saying, we had a client came to our office sometime 2 weeks ago who had a similar situation. In this case, we called the employer, and the employer said, well, this employee, we have comorbidities, and we are very ill people, and the worker is saying that she's not going to be tested, and she's not going to be tested for whatever reason, and she's not going to be, because it's for religious reasons, I should say, and she's not going to either take the vaccine or anything like that. And the employer had to make a decision as to what to do. In this case, this worker would have been working for this employer for some 21 years. And we simply advise that you go back to your employer. We advise the employer, you all maybe you should have some dialogue on this. Education sometimes is necessary. Sometimes if both parties hold steady to their perspective, their point, I am not taking it, you have to take it to come back out to work, then you have to find a middle ground. Compensation may be necessary, but it is not an easy question, because this is another similar to this, different from the security company scenario, but this is another scenario that raises questions as to how we deal with it, and it shows up the complexity of this particular issue in the workplace. Alana.
Thank you. We have another live question from Marine Consultants, and it reads, if employees do not want to take the vaccine provided by the government of TNT and have a vaccine preference, the employee is reluctant to take the available vaccine. However, customers eventually may start to put stipulations in place that affect business, as the employee may be unable to travel for training or attend certain jobs as a result of their unwillingness to take the vaccine. How does one treat with that situation?
Well,
That is another, in my opinion, another complex question. The thing is, as an employer, you going into a contract with your eyes wide open, knowing that you don't have either the employees who are vaccinated or the employees who are willing to be vaccinated, and you are going into that contract. That is something you have to think about before you take that kind of contract. And clearly, with vaccine hesitancy, a main thing among some workers, your contractors, the people who are seeking to go into contract with you, get into contract with you, they too have to consider the reasonableness of the exercise. So this will have to be a dialogue between marine consultants and their contract, and some kind of decisions has to be made, whether we have the people to fill that kind of contract or to do that, or whether we need to employ new people to be able to do that who have the vaccine. Because as I said, you can employ persons and put as a condition in your contract that you have to have the vaccine within a certain period of time once it is available. And nobody can do anything about that. That is a condition precedent. You came into the contract knowing that is a condition in the contract. That is different and apart from a worker who has been working for years or for some time with me, have an existing contract, and you are now telling them that they have to be vaccinated to continue working. Elena?
Sure, thank you. Our next question asks, are there any Trinidad and Tobago jurisprudence which has been lobbied, passed, and implemented to protect an employee who would have taken the vaccine and died post the administration of the vaccine? Gentlemen?
Well, I certainly haven't heard of any case thus far with that, as we did establish in our preamble that there's no jurisprudence concerning COVID-19 and employment relationships. I don't know what it is in the civil courts. As yet, I have not read of any challenges to vaccine and post-COVID issues with deaths as related to. So it's very difficult to pronounce on those things. When we look at what is happening around the world, we can see different things, but different countries have different laws. And as Mr. Mathison says, it's a different scenario. If Parliament has made something law, then we will work from that back end come down, without which we do not have federal arrangements as in the US. So for instance, in some states, we realize that it has been upheld. So there's a case recently in Texas, the Jennifer Bridges versus Houston case, Houston Methodist Hospital, where the hospital implemented a compulsory vaccine policy. The worker did not take it and she was dismissed and it was upheld. So we have to look at what is going on around the world, and that is why there are no absolutes in this, and we do not advise workers, no employers, to take hard and fast rules where it comes to this, because you may be shocked at the outcome of your challenge. And at the end of the day, I did say it will take long. The court is not a 2-day scenario. We're talking about resources. Whom does the resources favor most times in harsh economic situations? So you know that it's a process at the end of the day. But we don't have the jurisprudence to answer simply. I have not seen it. I have not read of it. I haven't read everything. But this is new ground. So this is new ground for everyone. So we should be very cautious in making pronouncements on what will happen or will not happen. We are guided by rules of industrial relations, good industrial relations practices, and we can use those rules. But even those rules may fall short in new scenarios, especially if it could be argued that the intention of the employer was to be very protective and be very preventative concerning their workers, concerning their workspace. We have the Occupational Safety and Health Act, which is law, which gives the employer the duty of care and the due responsibility to provide a safe work environment. And that may include certain types of policies depending on the nature of work. So we await to see, we do, and again, we ask for dialogue and meeting of the minds to avoid some of these hurdles.
Thank you.
Alana, that is an interesting question, because what it guides us in maybe the government taking advice from that and probably making some kind of probably vaccinating indemnifying their vaccinators, so that to a certain amount, because it will be very unfair even if a law is passed, which is that's kind of like a distant impossibility. But even if a law is passed to aggravate my rights under Section 4 of the Constitution, to say that I have to take a vaccine, and when I take the vaccine, I die, and then there is no compensation. So that is something maybe a question that the government could consider at some point in time, because that is real. Elena.
Thank you. Our next question asks,
Yeah, Elena.
if a worker does not take the vaccine and the workplace does not roster the worker, should the worker still be on payroll, or will their pay be suspended until they go on the roster?
That again is a very good question, because what you are doing there, you kind of like unilaterally altering the terms and conditions of my contract.
And you're
If you're dismissing the worker. If I am working for you, and for whatever reason outside of my contract, you take a decision not to roster me, and that reason is for not taken the vaccine, then you've dismissed me, and then that is grounds. That's a dispute right there. And this is what we are saying. We are saying that before you make those kind of decisions, maybe you should consult a professional, or you should have dialogue with the worker. Because the answer to all of these lies in the employment contract. And as I said, do not say that you do not have an employment contract. An employment contract is deemed to exist once there's an employment relationship. So the answer to that is, it is not advisable that an employer do that. Thank you, Elena.
Yes. Next question in the live section asks, what actions can an unvaccinated employee take if he or she is terminated by his or her employer for refusing to take the vaccine? Gentlemen?
Okay, let me answer that question. Now, what we realize is that most workers in Trinidad and Tobago are not unionized. But that doesn't stop, or that doesn't prevent a worker from redress, because under Section 51 of the Industrial Relations Act, it speaks to a worker who are not a member of a union going to the Ministry of Labor, raising the dispute through a trade union, and beginning the process of a dispute. So a conciliation will ensue, and then if things fail there under Section 59, the minister may report the matter as an unresolved trade dispute through an unresolved trade dispute certificate, and it goes to the industrial court. In that case, A matter like that will be heard at the industrial court, and the court, as I said, would be guided by its powers under Section 10 of the Industrial Relations Act, which would look at the reasonableness or the equity in the decision. And if it was determined that the decision was made and that it was harsh and oppressive or contrary to good industrial relations practice, I am certain that compensation will be awarded. Elena.
Thank you. Another question asks, if one is a principal of a private school and the principal and staff are not interested in taking the vaccine, how does this affect the school legally? Gentlemen?
Well, legally, remember, vaccine, it isn't law, right? So the principal is a private scenario as far as I'm seeing. When I'm sticking to the employment side of it, is breaking no law. You're contravening no law by not taking the vaccine. I don't know if the question asks if it's mandated by maybe the owner that the workers have the vaccine and the principal and the workers don't want to take the vaccine for whatever reason. And again, there might be good reasons for that not being so, and therefore they may come to the mutual understanding that the employment relationship has to end. What cannot happen is that there be a high-handed approach to re-emphasize what Stephen says on any side of the coin. On any side of the coin in dealing with mandatory vaccines or forcing people to be vaccinated. That I am sure will not go down well until such time, and we have heard even our good Prime Minister says that, there may come a time where that might be considered. It is a discussion, it is something being touted about, but again, some people are reacting to the fear and panic because employers, some of them, and not all, have started to show signals of carrying out mandatory policies. And again, as I said in my discussion, that too will be tested. That too is up for challenge.
Thank you. Even as we, Stephen, you wanted to make a contribution to this question?
No, I said I totally agree with the contribution of Ronaldo.
Okay, thank you. We have time for just one more, so allow me to pull it from one of the offline submissions, please, where another person has asked if you can speak to what would have happened at Mario's. Gentlemen?
I would have read the story on the Mario's issue. I don't have all the facts, but again, we would have answered those questions. Workers who were on furlough, workers who have been temporarily laid off were not terminated. So it meant layoff simply means a temporary suspension of your terms and conditions for a period of time. And therefore, your tenure remains intact. So I am still an employee. In this case, was it Mario's? I'm still an employee of Mario's. So if my contract there did not say that I have to have a vaccine before I re-enter work, then it will be very difficult to take somebody else in the workplace before me. And there are cases like that. There are cases which speaks to the 3 months layoff and that kind of thing that you can research. So it will be interesting to find out how the employer arrived at that. As we have been saying throughout this program, some kind of dialogue have to be had. But again, it will be interesting to find out how the employer arrived at that and who advised the employer. Yolo?
Well, as we've been saying for the entire night, any decision carried out either way can be challenged. I would wait to see what happens. Again, I am not too acquainted with the facts, And sometimes even on the media, you do not really get the important and the imperative facts of any scenario, of any case. So it's difficult to pronounce. But on the face of it, it seems quite strange that such a stance was taken. Again, we wait to see, or we wait to hear more. I will do my own research as to how that really was carried about. But we must note that these things, especially in such a litigious society, will not go unchallenged at all by workers. And they have a right. They do have a right to query. They have a right, because I think we have to understand how the industrial court and the court sees the employment and somebody's job and the termination of that employment. We see it sometimes as just a matter of economics. Some people say it's a social issue, but really and truly, that has a view and a perspective in itself in the judgments of the court as to how the decision was arrived at. Exactly. So we do respect, and the court respects the employer's prerogative, to govern and to manage his or her workplace. But again, the process will become very, very, very tenuous, and it'll be under grave scrutiny.
Thank you, gentlemen.